They imposed a $3.2 million fine on Elon Musk, assuming he would simply pay it and carry on. However, his actions in that courtroom took everyone by surprise, leaving even the judge utterly astonished. The morning in courtroom 7B of the federal courthouse in Fresno, California was expected to unfold without incident. The rain whispered softly against the windows. The clerk moved the papers around. Journalists lingered listlessly, fiddling with their equipment and nursing lukewarm coffee from disposable cups. Suddenly, the door swung open and in walked Elon Musk all by himself. Without a security detail or legal entourage, he stood there in a gray suit and dark tie, his expression inscrutable. Onlookers looked up, intrigued yet unfazed. Musk faced a summons for purportedly breaching court protocol during a prior corporate litigation hearing related to one of his companies. The court's complaint states that he revealed confidential information from the proceedings at a press event weeks earlier. It appeared to be a straightforward violation of conduct, plain and evident. That morning, Judge Deirdre Colton took the bench, her demeanor sharp and precise, renowned for her straightforward approach, particularly regarding high-profile figures. She glanced up from the bench, caught Musk's gaze for a fleeting moment, and swiftly turned back to her notes. "Elon Musk," she started, her tone steady yet assertive. "You are in breach of federal court orders concerning confidential testimony. A penalty of $3.2 million must be settled within a span of 14 days. Silence reigned, devoid of any gasps or dramatic pauses. This was, indeed, Elon Musk. Wealthy tycoon, corporate leader, media powerhouse, a couple of million? That wouldn't rattle him. Yet, there was an undeniable quality to his stance, hands casually folded, devoid of any reaction or dissent, that brought about a quiet transformation in the atmosphere. Judge Colton leaned in, seemingly anticipating a response. "Are you clear on the terms of the judgment?" she inquired. "Text, I do," Musk replied, his tone steady, "but I would like to respond." Now, heads turned, and a few reporters straightened in their seats. The man hadn't brought a lawyer, and here he was, requesting to speak for himself in front of a federal judge. Judge Colton appeared unconvinced. "Mr. Musk, I suggest securing legal counsel before proceeding further." "With all due respect, Your Honor," he stated, "I believe it would be more fitting for me to take care of this matter myself." She nodded slowly. "Continue." And that was the moment when everything started to change. Initially with a hint of discretion, Musk delved into his inside jacket pocket and retrieved a solitary sheet of paper. It was meticulously arranged, without a binder or a folder. He set it down on the table before him. "I'm not contesting my previous statements," he began, "but I am questioning the applicability of the gag order in the context it was invoked." That certainly caught attention, a murky legal situation. He elaborated that the order mentioned in the contempt filing was linked to Section 35B of the protective hearing order that was issued on March 11th. However, as outlined in subsection 35(3), public safety exceptions allow for disclosures under federal fair use exceptions, particularly when the disclosed content pertains to risks that affect stockholders. Judge Colton blinked slowly. Journalists started to write. "I highlighted a single facet of a manufacturing process that, if misinterpreted, could pose risks for consumer safety. I refrained from naming individuals and did not reference any confidential documents." He mentioned that he drew upon his own observations to express his concerns. Silence enveloped the courtroom. A paralegal leaned in, murmuring something to a fellow colleague behind him. Even the bailiff stationed by the door appeared somewhat perplexed. Judge Colton arched an eyebrow. "Are you implying that you have protection under federal whistleblower laws?" Musk stated that the fine imposed on him might go against the precedent established in Stansfield v. U.S. In the case of Tech Holdings, 9th Circuit, 2004, the court determined that executive disclosures benefiting the public interest are not subject to penalties under sealed protection, provided the statements do not adhere to the original boundaries of the gag order. There it stood, a particular instance, a decision, a recorded precedent. It was not an extravagant display. It lacked any form of theatrics. It was deliberate, composed, precise. In that moment, it became clear to everyone present. However, Judge Colton had a strong aversion to unexpected developments in her courtroom. And Elon Musk had just changed the narrative. Judge Colton paused before replying. She leaned back, her fingertips interlaced, gazing at the man who had just recited circuit law as if he were a rightful member of the council. For an extended period, the sole noise in the courtroom was the hum of the overhead lights and the sporadic clatter of a reporter's laptop keys. "Elon," she finally uttered, shedding the formality for the first time. "It becomes clear that citing previous cases in this courtroom does not ensure immunity. This is not a matter of theory. This constitutes a federal penalty. Musk remained unfazed. I'm aware, but it's not just a theory if the penalty disregards its own framework. It wasn't about his words. His delivery was deliberate and steady, as if he had rehearsed those words countless times, yet not in front of a reflection. It emerged from a different source, assurance, not hubris, not allure, merely lucidity. The ambience of the courtroom had shifted. The judge ceased addressing the individual charged with misconduct. She found herself in a discussion with someone who seemed to possess genuine knowledge on the subject. A voice from the rear murmured, "Why hadn't he brought his legal team?" Another bent forward. He must have intended to make this personal, and perhaps he did, for at this point it had become personal. "Mr. Musk," Colton inquired, reverting to a more formal tone, "are you seeking a formal motion to dismiss the fine?" "Indeed not, Your Honor. I am seeking a reevaluation in accordance with Statute 1287F Provision 4. I contend that the court's penalty surpasses the limits set by the statute in situations where sealed disclosure lacks specificity and aims to tackle urgent shareholder issues." He took a moment, and I can share instances of decisions that resonate with that reasoning. Judge Colton let out a breath, clearly taken aback. "If I weren't, I wouldn't be here at all." It had an air of peculiarity, not in a disrespectful manner, but rather in a way that felt unexpected, akin to observing someone articulate the guidelines of a game they seemed unlikely to grasp, much less triumph in. She signaled to the clerk, requesting the transcript from the March 11th hearing and the complete ruling from Stansfield v. U.S. Tech Holdings should be on my desk by this afternoon. The clerk rose and vanished into the corridor, leaving an abrupt stillness in the space. "Elon," she repeated, this time with the tone of someone striving to grasp the reasoning of a younger mind. "You're aware of the gravity of the situation, aren't you? You're not merely challenging a penalty. You are pushing the boundaries of judicial discretion." He nodded, affirmatively, yet with a tone of respect, "Your Honor. If a court can impose boundless fines for statements that fall outside the explicit language of the gag order, then what are the boundaries of that discretion? Where does it conclude?" A representative from the Securities and Exchange Commission, positioned behind Musk, jotted down notes on a legal pad. Another lawyer from a competing firm discreetly pulled out his phone and began typing beneath the table. This had evolved beyond a mere contempt hearing. It transformed into something entirely different, a pivotal instance, the sort of moment that future law students would reflect on, where a defendant opted against battling the charges with legal tactics or drama, instead relying on reason. Musk approached the side table, retrieved a printed copy of the March 11th order, which he seemingly brought himself, and presented it to the judge. On pages 3 and 4, he mentioned, "In the third paragraph, you'll find the exception clause." Colton remained focused, not glancing up as she took the paper. Her gaze darted swiftly, her lips forming a tight line. "This court has the ability to make choices," she stated, "but even those choices," Musk responded, "have limits." Silence enveloped the room. Then gradually she raised her gaze, devoid of anger, lacking even annoyance, merely touched by a sense of understanding. She held onto the fine for the moment, but a flicker in her expression hinted that the confidence supporting it had begun to wane. Yet, if Elon had breached the dam, the true challenge was still on the horizon. To what extent would the water reach? When the courtroom came back to order after lunch, news had circulated. Local reporters had already shared snippets of Musk's portrayal on Twitter. National outlets started to take notice. The corridor outside 7B buzzed with camera crews, legal experts, and individuals who had never shown interest in procedural laws, all suddenly questioning, can Elon really come out on top in this? Within, the atmosphere was subdued, yet far from serene. The atmosphere was thick with tension, as if everyone was poised in anticipation, ready for a critique, a misstep, anything that might reveal him as just another tech guy masquerading in a courtroom. Yet, he remained steady, unyielding. Musk sat at the unadorned desk, hands neatly folded, his expression devoid of emotion. He neglected to check his phone. He remained still, his gaze fixed ahead, patiently biding his time. Judge Colton re-entered the room, clutching a yellow legal pad filled with annotations. She hesitated before taking a seat. "I went through Stansfield 2 times, she mentioned, "and I examined subsection 35B of the gag order. Your insight regarding the exception clause was indeed correct." A soft whisper rippled through the gallery, yet she persisted in raising the copy he had given her. "This exception is relevant solely in situations where the disclosure pertains to immediate threats to consumer safety, rather than mere speculation. Your remarks during that press event indicated a possible risk, rather than a definitive one. He gave a slight nod. That's reasonable, but the phrasing doesn't necessitate validation. It demands sincerity. The court operates under a legal standard that protects good faith disclosures made within that framework, regardless of whether the concerns ultimately prove to be non-lethal or exaggerated. She gazed at him intently. You're balancing precariously, Mr. Musk. I've traversed tighter paths, he responded. A couple of soft laughs emerged from the back row. Even Judge Colton permitted herself the slightest hint of a smile, but only for a fleeting moment. I also examined your timeline, as she mentioned, returning to the bench. Your remarks were made 2 hours following the hearing. The timing indicates that you might have communicated prior to obtaining the complete written order. Are you suggesting that you lacked access to the language? Musk gave a slight shake of his head. No, I had access, but the oral summary of the hearing was ambiguous. The clerk sent the complete transcript 6 hours later, and by that time, the media had already obtained my statement. Silence fell over the courtroom once more. Judge Colton inclined closer. Are you asserting to this court that you acknowledge the timing, yet deny the intent? Precisely. I aimed to notify shareholders about a trend I suspected could present a long-term threat. It had nothing to do with pride, it wasn't for the sake of publicity, and the information I cited wasn't sourced from confidential files. The information originated from our internal audits. That signifies ownership for me. A young attorney in the gallery murmured to her companion, He's unraveling every detail. Her colleague murmured in response, Indeed, and somehow it's managing to stay intact. Colton perused her notes once more, then raised his gaze. You know, she remarked, this court doesn't typically take kindly to being corrected by those outside its ranks. Musk responded promptly. Perhaps it's time to reassess the habit. There it stood, confident, straightforward, yet not arrogant. The tone lacked the intention of someone eager to prevail in a debate. It originated from an individual who held the conviction that the essence of truth outweighed the identity of the speaker. For a few seconds, the courtroom was quiet, not frozen, just quiet. It felt as though everyone had been subtly unsettled, yet no one was willing to acknowledge it. The judge addressed the court once more, this time with a measured pace. This court is being compelled to examine precedent that has not been relevant for more than 10 years. He stated that he is merely requesting the court to adhere to its own regulations. Colton drummed her pen against the desk, once, then twice. I will consider this carefully. We shall gather again in 24 hours to reach a conclusive decision. At this time, there will be no additional comments to the press. Got it? Got it. She rose, collected her files, and exited in silence. Elon lingered in his seat for a brief moment, then composedly collected his papers and exited the room. Neither like a victor nor like a defeated soul. Simply a person who expressed what was essential to express. As he entered the hallway and caught sight of the throng of reporters gathered, the realization dawned on him. This had transcended the confines of the courtroom. A national conversation was on the verge of unfolding. The following morning, the gallery was bustling with anticipation even before the doors swung open. Journalists arrived 2 hours ahead of schedule, gripping microphones and power cords as if they were armaments, surveying the parking lot for a sighting of the individual at the heart of the situation. Individuals traveled from nearby towns solely to witness the event unfold. All seats were occupied. Even Judge Colton's own bailiff had to remind the audience that this was a federal hearing, not a film. And yet, it was difficult to shake the feeling that something extraordinary was unfolding. Musk slipped in once more, clad almost exactly as he had been the previous day. He wore the same suit and had the same expression, yet there was an undeniable shift in the aura he projected. He had transcended the status of a mere billionaire. He was the individual who entered the courtroom and, through pure logic and composure, prompted a federal judge to reconsider. The lawyers positioned behind the prosecution table had increased overnight. Now there were two familiar members from the original team and a fresh presence from the Office of Special Counsel. That in itself conveyed a great deal. At 10:02 a.m., Judge Colton made his entrance and brought the room to attention. "I've gone over the materials shared yesterday," she started, "and I've consulted with a group of legal advisors from within the district." That statement carried a significant impact. Judges typically refrain from such actions unless a significant discomfort has arisen. Elon Musk's actions, she continued, did breach the essence of courtroom protocol, especially concerning the maintenance of confidentiality. Nonetheless, the punishment originally imposed might have exceeded the powers conferred by the guidelines specified in Section 35B. "A moment of reflection," whispers. She turned her gaze toward Musk. "Your interpretation of the exception clause and your mention of Stansfield were correct, and while this court typically refrains from easily overturning its own penalties, the fine will be lowered from $3.2 million to a symbolic $25,000, recognizing both the violation and the legal reasoning that influenced this decision." There was no applause, but a wave of astonishment moved through the room. Elon remained expressionless. He remained still, offering no acknowledgement. He offered a subdued, "Thank you, Your Honor." The judge continued, "I want to clarify something. This court will not extend leniency based on your financial standing or societal position. Your preparation, respectfulness, and precision have rightfully earned you this reconsideration. Such occurrences are rare, yet they hold significance." A woman sitting behind Musk leaned in toward her husband and murmured, "I expected him to be arrogant, but he's quite the opposite. He's simply unique." The judge shut her binder. Court is adjourned. The crowd rose to their feet. Journalists hurriedly made their way to the exit to submit their articles. Musk lingered for a moment, observing the judge as they departed. He pivoted, strode past the quiet gallery, and departed through the same entrance he had used before. Yet beyond those confines, the world was crafting its own narrative. Headlines began to emerge almost instantly. Elon Musk contests court penalty, emerges victorious. Judge alters decision following Musk's self-defense that stirs the atmosphere. A single individual, devoid of legal representation, navigating through an extensive array of legal precedents. Commentators started to engage in discussion. Was this a display of legal brilliance or merely another instance of the wealthy operating under a separate set of guidelines? Did it indicate that the judicial system could be swayed by those with sufficient influence? Or that reality can still influence even the most inflexible structures? There are those who think Musk meticulously crafted the entire event, a carefully designed performance aimed at garnering public sympathy. Some hold a completely different view, suggesting that he was entirely ready to accept defeat and merely spoke because it seemed appropriate. However, there was one thing that could not be disputed. It was a sight that no one could miss. Not in a headline, not in a tweet, but unfolding in the moment. A man stood in a courtroom confronting the very system that sought to define him and altered its course, not through wealth or power, but through the power of his words. As the clamor outside intensified, it became clear that the true tempest was just beginning, for the public was now brimming with inquiries that the system was ill-prepared to address. That same afternoon, Judge Deirdre Colton sat in her chambers, accompanied only by a cup of coffee that had long since lost its warmth and a legal pad brimming with unexpected annotations. Her assistant had stepped out. Her phone vibrated with a flurry of missed calls from old law school friends and journalists she hadn't heard from in ages. She gazed at the door for a prolonged moment before redirecting her attention to the notepad. In her own handwriting, 5 words were underlined. He wasn't mistaken, not completely. Colton had a history with controversy. Throughout her 26 years on the bench, she managed racketeering cases, class actions against pharmaceutical giants, and civil rights disputes that captured national attention. Yet, she had never met anyone quite like Musk, a person who entered her courtroom, communicated directly, and unraveled a multi-million-dollar penalty with nothing more than footnotes and federal precedent. What troubled her was not the necessity of lowering the fine. He compelled her to acknowledge that the court may have exceeded its bounds. She revisited the ruling once more. Clause 35B, exception provision, intent of the whistleblower. There it lay, clear and straightforward, tucked away on page 4, precisely as he had predicted. She jotted notes in the margin. Are we overlooking this? What is the reason? The sound of a knock at the door broke through her reverie. Her assistant returned with a small folder. He addressed the judge. The Office of Legal Oversight has made contact. A brief on the Musk adjustment is due by Friday, and Channel 12 is requesting a statement. She dismissed the second part without hesitation. No media coverage. He hesitated. There's additional information. Students studying law at UC Davis are sharing the transcript. Instructors are incorporating it into their legal ethics dialogues. It's becoming quite the phenomenon. She arched an eyebrow. An object? He nodded, a hint of uncertainty in his demeanor. They refer to it as the Fresno defense, akin to when a defendant turns the courtroom dynamics by leveraging the system's own mechanisms. Colton nearly chuckled but held it back. She whispered, "Please close the door." With a decisive snap, she fixed her gaze on the screen before her. The unrefined transcript from yesterday's session was on it. Elon's words, composed, rational, and meticulously chosen, shone like emphasized passages in a scholarly text. She scrolled once more, pausing at a particular section. If a court has the authority to impose unlimited fines for statements that fall outside the explicit language of the gag order, what are the boundaries of that discretion? Where does it conclude? That one lingered as it posed a question devoid of a straightforward solution, and every judge across the nation would be contemplating it now. In a quaint cafe tucked away on Ashland Avenue, Musk lingered in the shadows, his gaze fixed on the world outside as his assistant engaged in a hushed conversation on the phone nearby. He was not in a festive mood. He was not available for interviews. He was merely contemplating. A woman in her late 50s walked up to the table, cradling a to-go cup in her hands. "Excuse me, sir," she said softly. "I just wanted to express that while I may not fully agree with everything you mentioned, I watched it online and it resonated with me. The manner in which you conducted yourself, it held significance." He glanced up, taken aback. "Thank you," he responded with quiet sincerity. With a gentle smile and a single nod, she turned and departed. In that instant, silence reigned, devoid of any acclaim or celebration, just a fleeting pause in time. A serene moment. At the courthouse, Colton revisited a confidential memo from the district's legal review board. The final paragraph conveyed it unmistakably. Although the decrease in penalty came as a surprise, it demonstrates the court's ability to recognize its own constraints when faced with solid legal reasoning. This is not a mark of weakness, but a reinforcement of judicial integrity. She gazed at that sentence for a moment, contemplating its weight. At that moment, she finally permitted herself to exhale, feeling a sense of relief wash over her. Yet, if one courtroom could tremble in such a manner, what might unfold when the wider legal system began to take notice? By the next morning, it wasn't only those in legal circles or the creators of headlines who were buzzing, it was the everyday people as well. Drivers exchanged thoughts on it during their breaks between rides. Barbershops in Fresno and Bakersfield exchanged phrases like gag order and whistleblower clause, reminiscent of a lively discussion about a playoff game. On a late-night AM station from Modesto, a caller remarked, "I don't even like the guy, but what he did in that courtroom, that was something else." Cable news shows rushed to secure constitutional experts. Clips of Musk's courtroom appearance began trending, not due to theatrics, but for the absence of them. There was no table slam, no outburst, just a man methodically addressing a fine he deemed unjust. And somehow that was more enthralling than any scripted performance. One segment on a national morning show featured a side-by-side comparison, Elon's transcript alongside Judge Colton's revised ruling. A former federal prosecutor shook his head on live television. He strategized meticulously, foreseeing the counter-arguments before they could surface. The term Fresno defense started appearing in opinion pieces. Editorial boards began to pose challenging inquiries. How frequently did courts impose fines without adequately recognizing legal exception clauses? How many individuals had merely complied due to a lack of time, resources, or the courage to confront the situation? In that moment, Musk transcended his status as a billionaire. He became an emblem of an unarticulated desire, a testament that the system could still be contested and occasionally manipulated if one possessed sufficient understanding. However, not all perspectives aligned with this view. Within the Department of Justice, an internal memo was distributed cautioning federal judges regarding the potential precedent this could establish. Although Musk's behavior was unconventional, the memo suggested that his arguments, if left unchallenged, might pave the way for increased courtroom disturbances by prominent individuals opting to represent themselves. A writer for a San Francisco publication labeled it perilous. "We cannot allow courtroom theatrics to be romanticized, even when the individual behind them boasts a net worth in the billions. The law is not a trivial matter." However, some voiced their dissent. A former judge from Sacramento crafted a reflective op-ed. Rather than contesting the law, Elon Musk chose to leverage it. He reminded the public and the judiciary that no system is beyond scrutiny. That's not insurrection. That's democracy operating precisely as it ought to. Even some skeptics couldn't overlook the events that unfolded. At a law school in downtown Los Angeles, Professor Joanna Menendez commenced her civil procedure class by displaying Musk's transcript on the board. Regardless of personal opinions, she informed her students, "This is the manner in which one communicates after thoroughly engaging with every line twice. This is the moment you enter a space where the challenges loom large and declare, here's what you overlooked." In Fresno, Elon kept his silence. No media appearances, no public remarks. He resumed his duties, everything seemingly normal. Yet, his team observed a shift in the way colleagues acknowledged him during meetings. There were more inquisitive looks, more cautious voices. One engineer from one of his subsidiaries inquired, "Were you anxious in there?" Musk replied, "Yes." "Did it show?" "I don't believe it had any significance because the reality is that fear never prevented him from rising and expressing himself. He didn't undermine the court. He didn't succeed through a loophole. He adhered to the rules. He simply examined them more closely than anyone anticipated, and that's what remained in people's minds. It wasn't about the money or the cameras, it was the notion that understanding the rules might hold as much power as defying them. While Elon advanced, the system he confronted remained unable to escape the impact of that moment, with its effects just beginning to emerge. Weeks later, after the headlines faded and the cameras shifted to fresher, more dazzling scandals, the story lingered, subtle yet unwavering. In various offices and courtrooms nationwide, judges referenced the case casually. Law firms revised their training materials. Professors continued to incorporate Musk's arguments into presentations labeled "When the defendant pushes back." However, the most significant influence wasn't felt within the institutions. It resonated with individuals. Marcus Albright, a 34-year-old mechanic from Flagstaff, had never engaged with a courtroom narrative before, yet he stumbled upon a 6-minute clip from the hearing on YouTube featuring Elon Musk speaking with merely a piece of paper before him. No arrogance, no raised voices, just a man conveying a message that demanded attention. Marcus wasn't particularly fond of billionaires, yet he found himself watching that clip twice. Afterward, he printed it out and took it to work. Why would you choose to print it? What did his coworker inquire? Because if a man like that can walk into a courtroom and tell the truth without hiding behind 30 lawyers, maybe I can speak up at my next union meeting without second-guessing every word. In Sacramento, a 62-year-old retiree named Barbara Levis filed a motion to revisit an old fine from a housing code violation she felt was mishandled. She referenced the Musk case to the judge. The court clerk, much to her astonishment, was already aware of the situation. While her appeal wasn't completely overturned, it underwent another review. Ultimately, she received a partial refund. The takeaway wasn't that Elon Musk had outwitted the system. It was that the system, when faced with logic and composed resistance, could still halt, reassess, and acknowledge its mistakes. That was the lasting impression. Within the confines of the courtroom, Judge Deirdre Colton's ruling was devoid of any sense of admiration. It was not a matter of personal feelings. It was fundamentally about the structure. The evidence was undeniable. The reasoning was sound. And once she grasped it fully, she acted in accordance with her role. She adjusted the direction. Yet, beyond the courtroom, it didn't seem routine. It felt like something different, a moment where responsibility ceased to flow in just one direction. Weeks later, during a podcast, a host asked a pointed question: was this a matter of power or precision? The guest, a legal analyst, took a moment before responding. Precision is power. It simply speaks softly. That's what made this so impactful. Musk didn't shout. He elevated the standard. Perhaps that was the takeaway. We often associate influence with commotion, with theatrics, with grand displays. Yet this narrative revealed a different truth. It remains feasible to confront authority with poise, articulate speech, and the law as your ally. It served as a reminder to everyone, regardless of their origins, that understanding your position can often outweigh any title or reputation. When you stand firm in your beliefs and understand the reasoning behind them, even a federal courtroom must pay attention. Ultimately, Elon did not emerge as a hero. He didn't exit as a villain. He left as a man who understood the Ralas message and ensured that others did too. In an era where noise frequently obscures the truth, perhaps that's precisely the kind of subtle strength we require more of. Here's the essence. Never take for granted that every system is unchangeable. Stand your ground even when the space seems more expansive than your own presence. Absorb each word, understand your foundation, and express yourself, for even the most powerful voices can be muted by someone wielding the right phrases and the bravery to articulate them. If this narrative resonated with you, provoked thought, or reaffirmed the importance of reason, consider subscribing to the channel. We have more narratives on the way, ones that provoke, uplift, and linger in your mind long after the lights fade.